This is lesson 9, the right to the freedom of expression. The first question we have to ask is, what is the freedom of expression? Now, the freedom of expression, the right to the freedom of expression, is found in section 16 of the South African Constitution. The first thing you should notice about the Constitution is that we can divide it into two parts. The first part will be 16.1 and then the second part will be 16.2. Now, 16.1 focuses on what is specifically included under the right of freedom of expression. Here we have the freedom of press and other media, the freedom to receive and impart information and ideas, artistic creativity and academic freedom, and freedom of scientific research. Then we have 16.2, which tells you what the freedom of expression excludes. Propaganda for war, incitement of imminent violence, advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. This is known as the hate speech section. Now, this section 16.2 differs from the interim constitution. It also sets apart our constitution from Western liberal theory. It's important to keep this in mind when comparing material of section 16 to the First Amendment of the United States of America. Now, this is the most famous freedom of expression section in the world, and you'll hear it, for example, in lots of movies. This is a free country. I have the right to freedom of speech. But we cannot compare the South African Constitution and freedom of expression to the American one. The reason why is South Africa's freedom of expression is not as extraordinarily valued as in the US Constitution. What I mean by this is the US Constitution does not contain section 16.2. They have an almost unlimited freedom of speech. Now the question is, how should we then interpret the right to the freedom of expression? Remember, usually the country uses a comparative way of interpreting certain sections, meaning they compare it to other countries. Now, I just told you that we cannot use the American section because it's much more liberal than ours. But the US First Amendment case law has had considerable influence on the interpretation of this right. But even if freedom of expression in the South African Constitution is not as extraordinarily valued as it is in the US Constitution, we still need a sense of what its value is to us as a country in order to know what its legitimate limits are, especially for case law. We need to know what exactly this right is for the Constitutional Court to adjudicate it. Now, the first thing we know, and this is important, is the interpretation of the freedom of speech must still be generous, purposive, and must give expression to the underlying values of the Constitution. Remember, the underlying values would be dignity, equality, and freedom. So whenever the Constitution has a hate speech case or a freedom of expression case, they will have to interpret the right according to these underlying values. Another intervention on the idea of interpreting the right was done by Ronald Dworkin, and he identified two important categories in which the various defenses of free speech can be classified. Now, the first one is instrumental. So in other words, when the Constitutional Court weighs the right to freedom of speech, they can use these two grounds to see how important the right is. The first one, as I've said, is instrumental. And the instrumental argument defends free speech because of what it can do for us. So they say it's not because people have an intrinsic moral right to say what they wish, but because allowing them to do so will produce good effects for the rest of us. So it's instrumental to being a free country that we be able to speak our minds. The second one is constitutive. Now, this sees free speech as valuable because expression is an important part of what it means to be human. It recognizes the fact that we are responsible, moral agents, that we can identify what is good and bad in politics, and what is true and false in matters of justice and faith. Freedom of expression means that we retain our dignity as individuals, only by insisting that no one, no official, and no majority has the right to withhold an opinion from us on the ground that we are not fit to hear and consider it. So basically what we're saying is when the Constitution weighs the importance of the freedom of expression, except for the fact that it needs to focus on the underlying values of the Constitution, when it considers what it means to us as a country, it can look at these two grounds. The fact that it's instrumental to us and that it's constitutive, that it recognizes. Now, in your textbooks, you will see that there's a much more in-depth discussion on instrumental and constitutive. For purposes of this specific section of your textbook for test and exam purposes, you only need to know what's on this slide. Know that when the Constitution looks at the freedom of speech, the Constitutional Court, it must be generous, purposive, and the underlying values of the Constitution, as well as the two reasons why we think it's important. Now we're going to move on to section 16.3 of your textbook, which is the expressions afforded specific constitutional recognition. Okay, so the first right that we have, the first expression afforded specific constitutional recognition. So what this basically means is we all have the freedom of speech, but there are specific freedoms of speech that have specific recognition. The first one being freedom of the press. Now, section 16.1 protects the freedom of the press and other media. Now, the rationale for constitutional protection of press freedom is the important contribution made by the press to one of the goals of freedom of expression in general, and that is establishing and maintaining an open and democratic society. So the press has an important role to play in maintaining an open and democratic society because the press usually uncovers corruption, fraud, dishonesty. So the fact that we want a transparent democratic society gives the press a very important role. So the press is protected by the freedom of press or the freedom of expression, but it also has a duty to promote it on behalf of the rest of society. As the Constitutional Court has explained, the ability of each citizen to be a responsible and effective member of a society depends upon the manner in which the media carry out their constitutional mandate. The media thus rely on freedom of expression and must foster it. In this sense, they are both bearers of rights and bearers of constitutional obligations in relation to the freedom of expression. So when discussing the freedom of press, just remember they are protected by it, the press, but they also have the duty to promote it. Now, authoritarian regimes, this is regimes that have an authority or a dictator that rules them. They usually monopolize and stifle independent media. It's one of the first things they do. If you look at the apartheid state, they had complete control over the media. The reason being is specifically the idea of an open and democratic society. If you control the media, you can influence the way people think, what they believe to be true. We had the same problem a little while ago, a couple of years ago, about 2 years ago. The government wanted to control the media by prohibiting them from having any stories about bad service delivery. They said it was causing instability in the country and uprisings, protests, and they tried to control the media, but the media and the rest of the country came in uproar and they stopped that. But this is why freedom of the press is important. The moment we have a dictator or a regime that suppresses, one of the first things they try to do is monopolize and stifle the press so that the truth cannot get out. But now the question is, does this mean that the press has special status with regards to freedom of expression? Does it mean the press can say more than the normal person? They have the right to be more honest or uncover other stories? Now, this is an important question. For example, should they have greater protection against subpoenas, compelling them to disclose information? So if the government takes press to court and say, we want to know where you heard the story, who are your sources, does the press have any specific protection? Now, this question has been debated in the United States as an issue of interpretation of the First Amendment. And also in our own courts, it has been debated. Now, to thus far in South Africa, the press does not have more rights than any other speakers. Now, there were two cases in which we saw this. The first case was the case of First National Bank of Boston versus Bellotti, where Chief Justice Berger held that the specific reference to the press in the First Amendment does not give the press any more rights than other speakers. This is because there is no evidence that the framers intended to give a privileged position to the press. Secondly, it was unacceptable to single out and confer special status on a limited group of people, particularly in a group that is difficult to define. Now, if we look here, the second case, which is a bit more important, is the case of Holomisa versus Argus newspaper. Cameron in this case recognized the special role of the press in a constitutional democracy, as we discussed here, but also stated that this does not mean that journalists must enjoy special constitutional immunity beyond that what is recorded to ordinary citizens. Judge Cameron described the idea of press exceptionalism not only as unconvincing but also as dangerous. We cannot give the press free rein. So, for the discussion of freedom of the press, you need to know why it is important, that it's a duty as well as a right, the role it has in a dictatorship or authoritarian regime, and you need to be able to answer the question of whether the press has special status. This quote specifically here is with relation to the fact that it's a duty and a right. So this part of your textbook connects with this, and this case law connects with this part. So when discussing freedom of press, remember the right and the duty as well as the role of the press and what their right. Here is just an interesting fact sheet about who threatens the rights of the press. Violent groups, judges, media owners, security forces, trolls, and heads of state all threaten the press because the press has the right to uncover any of these people. Thing is the 2017 World Press Freedom Index. If you look at this, countries that are marked as black have little to no freedom of press. This is, you'll see more the Middle Eastern countries, and we have China here. Then good situations are countries with complete freedom of press. This is the Scandinavian countries, for example. And then yellow is the satisfactory situations, countries where the press have mostly freedom of press. And you'll see that South Africa is actually marked as a yellow country, with Lesotho being marked as a noticeable problem and Swaziland being marked as a difficult situation. Remember, this is not something you need to know for test purposes, but if you give me some facts, I will of course give you marks for this, but this is just for interest's sake. The second kind of freedom that is specifically protected in the Constitution is the freedom to receive and impart information and ideas. Now, if we go back to a freedom of press, you'll see in your textbook that there's a lot more discussion, more in-depth discussion. For test and exam purposes, only focus on that which I did on the slides. You won't be expected to discuss freedom of press for more than a couple of marks. Okay, now moving to section B, freedom to receive and impart information ideas, found in section 16(1)(b). Now firstly, there's no counterpart for this in the interim constitution. The specific enumeration of right to receive information ideas removes any doubt that this section pertains to both speakers and listeners. So the issue with this was, what if you are told sensitive information? Are you protected as a person who received the idea, who heard the idea, or is only the person who spoke the idea? Does freedom of speech limit to only the person who that speaks the idea or imparts the idea? Now, section 16(1)(b), the fact that it says receive and imparts, removes any doubt that it protects both the speaker and the listener. Now, this is very important, seeing as whenever you exercise your freedom of expression, there are always going to be people on the other side hearing your freedom of expression. Now, in the case of in the case of Case versus Minister of Safety and Security, a majority of the Constitutional Court expressed some doubt as to whether the right to freedom of expression, as found in the interim constitution, included the reception of ideas by those to whom they are communicated or presented. There was confusion about whether the right to freedom of expression in the interim constitution protected both the speaker and the listener. Now, the majority of the court found the prohibition of possession of pornography contained in the Indecent and Obscene Photographic Matters Act 37 of 1967 to be inconsistent with the right to privacy. However, Judge Mahora persuasively argued that the provisions of the Act violated the right to freedom of expression. She held that the right to freedom of expression embraced the right to receive, hold, consume expressions transmitted by others. So, in this case law, you don't need to know the details of the case, just know in Case versus Minister of Safety and Security, it was confirmed that both the speaker and the listener is protected by Section 1B. Now, the issue with this is that Section 16(1)(b) provides for the right to receive information and ideas, as opposed to general expression or the broader concept of expression. This could arguably make the right more limited in its scope. However, as long as the expression can be considered to convey information or ideas, its receipt is also protected without reference to the content of the expression. So this was just an argument that they had about whether information and ideas, there's a difference between information and ideas and simply speaking your mind. And the freedom of expression is supposed to protect whatever thoughts and feelings you have about things, but Section 1B only refers to not to expression but to information and ideas. So there is a question about whether this makes the right more limited in its scope. In your textbook, they then discuss the case of the Reek, which is specifically about child pornography. But for purposes of a test or exam, just know what is on this slide. This brings us to number C, the freedom of artistic creativity. Now, the idea that artists need to be protected and their right to express needs to be protected is very self-explanatory, because artists give radical criticism of on the way society functions. It's part of one of the roles of artists to give commentary on the way society functions. But their work may upset sensitive people, and that's why the government has been tempted to control the production and exhibition of art as a way of protecting people, because art can disturb people in a very big sense and it can easily offend. But in our constitution, freedom of artistic creativity, as long as it's not hate speech, is protected. There's also no distinction between art as a product of art or the process of creating art. So, for example, sometimes art can be a whole process. You can a painting, for example, the idea of the artist can be that you need to watch the painting being drawn and then painted and then the finished product. So it has been found in our courts that the production of art and the product of art both are protected by this section. And art is very broadly defined. It includes film and music. So if we have film, or let's say we have a song is released by a South African artist giving harsh commentary on our government, it will not, unless it promotes hate speech or incites violence or can be seen as propaganda for war, it will be protected. Now here I've put some pictures for you just to give you an indication of the type of commentary artists can give. This one is a very famous piece of art that was created while President Jacob Zuma was still our president. Behind the word spear of nation, it is a very visible sexual organ, and the idea of the artist was to give commentary on the role of Jacob Zuma in our country. And this was one of the pieces of art that was constitutionally considered maybe they should ban it. But in the end of the day, this section of our constitution protected the artist. If you look at the other pictures, these are all social commentary on, for example, the fact that we have so many child soldiers in the world, the fact that politics is based on lies, the idea that there are people dying of hunger in the world. This is actually a very famous photograph that the artist changed to give commentary on the fact that we have so many rich people in, for example, in the United States compared to children dying of hunger. This is the idea that media and social media is absolutely controlling our minds. And this is an interesting artistic movement that is giving commentary on the fact that Africans who were enslaved by Westerners is now westernizing themselves, becoming part of the system. But remember, you never have to agree with art, but it is constitutionally protected. The last one we have is academic freedom and freedom of scientific research. Sorry, second last one. All you have to know here is this right protects people in their academics. It was always part of the freedom of religion, belief, and opinion. Today it is a right on its own. Originally, it only protected institutions of higher learning, like university or colleges. Today, it's any academic enterprise. Now, at the core of this right is the right to research, publish, and to disseminate learning through teaching without government interference. This links with the idea of freedom of thought. This right vests in individual academics and not in universities, because universities, their decision-making bodies, such as their council or their senate, can be seen as part of an organ of state. So it has different rules that it needs to follow. So the fact academic freedom vests in you as an academic and not in your institution. Now, one of the reasons for establishing universities, after all, is to realize and protect academic freedom. If the state can prescribe to universities that no research critical of the government may be funded by the university, or no research critical of the government may be appointed, academic freedom will be stranded. So the idea of academic freedom and freedom of scientific research also has budgetary implications. The fact that you can do research about anything tells you that the government should fund research, even if it does not directly benefit the government. So the right implies a positive duty on the state to promote research and teaching by providing functional academic and scientific institution, or at least financial backup. The last one we have is freedom of speech in the legislatures. Now this is a very important freedom of speech. What it basically says is the people that sit in parliament has a certain kind of freedom of speech that the rest of the country does not have. They actually have special freedom of speech. So it's not a part of the Bill of Rights, but the Constitution grants members of the National Assembly, the National Council of Provinces, and the cabinet members special privileges and immunities for their activities in the Assembly or the National Council of Provinces or any of their committees. Subject to the rules and orders of the Assembly and the NCOP, they have an absolute right to freedom of speech. Remember, we do not have an absolute right as in America, but people in the legislature do actually. They are not liable to civil and criminal proceedings, arrest, imprisonment, or damages for anything they have said in, produced before, or submitted to the Assembly, the NCOP, or any of their other committees. So basically what it says is inside of Parliament or inside of these committees, these people can say what they want and how they want. And if you've ever seen the Speaker of an opposition party speak in Parliament, you'll realize that they basically have absolute freedom to say what they want. There's one case law, De Lille versus Speaker of the National Assembly, where the Cape Town court stated that the freedom of speech conferred by Section 58 is an absolute freedom, in the sense that it is subject only to the rules and orders of the Assembly. The Assembly violated this special free speech right by summarily suspending a member of Parliament. It was Patricia de Lille was suspended. In addition, the member's Section 16 right to freedom of expression was infringed. So they have Section 16 freedom of expression, but also Section 58 freedom of speech, which is given to them in the Constitution, not in the Bill of Rights, but Section 58 of the Constitution gives them this freedom of speech. In the same case of Patricia de Lille, you can see her here at the bottom of the screen. This is Ms. de Lille. The Constitutional Court stated that it can never be reasonably justifiable in a democratic society to impose a suspension that will deprive innocent members of the electorate of their representation in Parliament, when any such punitive purpose served by the suspension could equally serve by other punishments which do not compromise democratic representation. On appeal, the decision of the Cape High Court was confirmed. On the narrow ground, there was no legal authority permitting the Assembly to punish a member for making a speech by suspending the members of the proceedings of the Assembly. So what happened in this case is we had Mr. Lowell. She made a speech in the National Assembly, and they felt that it was very offensive. They felt her freedom of speech did not cover what she said, and she was suspended from the National Assembly. She, as the leader of her party at that stage, she was then not yet part of the DA, went to the court, the Cape Town High Court, and this was later taken on appeal, and both courts, the first and the second instance, confirmed the fact that the Parliament, or the National Assembly. Okay, so that was the end of the specific expressions included. Now there are specific expressions excluded. Now what this means is there are specific things that can be seen as freedom of speech that is excluded from constitutional protection, which means that if you make yourself guilty of this kind of speech, you will not be protected under Section 16. Now, it's colloquially known as the hate speech qualification. So people usually talk about hate speech as they mention all three of these things under one heading as hate speech. But it's actually three different ones. The first one, propaganda for war. The second one, incitement of imminent violence. And the third one, advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm, colloquially known as the hate speech qualification. So what it tells you is if you make yourself guilty of any of these three, there's a legal restriction of speech when it falls onto one of these categories that there is not a limitation of freedom of speech and it requires no justification. So legally you are restricted and by making yourself guilty of any one of these three, and it will not be seen as a limitation on your freedom of expression. So what your textbook states as categories of expression enumerated in Section 3 are not to be regarded as constitutionally protected speech. Section 16.2 therefore defines the boundaries beyond which the right to freedom of expression does not extend. In that sense, the subsection is definitional. Implicit in its provisions is an acknowledgement that certain expressions does not deserve constitutional protection because, amongst other things, it has the potential to impinge adversely on the dignity of others and cause harm. Very important. If you are asked to discuss the exclusions in Section 16.2, you need to be able to tell me this. You have to start your discussion with what the reason for 16.2 is. This is the reason. 1, 2, 3, 4, at least 4 marks will be lost if you do not discuss this. Then you also need to tell me that there are 3 types of speech: propaganda for war, incitement of violence, and hate speech. So on this page alone, you have 1, 2, 3, 4, 5, 6, 7, 8 marks just on this page alone. Now, the first one we have is propaganda for war. Now, the question we must ask ourselves firstly is, what is propaganda? Now, propaganda can be defined as information that is not objective. It is used primarily to influence an audience and further an agenda, often by presenting facts selectively to encourage a particular synthesis or perception, or using loaded language to produce an emotional rather than a rational response to the information that is presented. Propaganda is often associated with material prepared by governments, activist groups, companies, religious organizations, and the media. Okay, so when you discuss propaganda for war, give me 2 or 3 marks about what do you think propaganda means. So basically what this is saying is if we have any information that is being imparted on people with the idea of getting them to start a war, it will be seen as propaganda for war. So it's information that causes an emotional reaction in people and gets them angry, gets them to want to wage war. This is not protected by the freedom of speech. And when you do this, it can be seen as a criminal offense. Now, this can be found in the International Covenant on Civil and Political Rights of 1966. Now, the word war refers to acts of external aggression and not violent internal resistance to the government of the day. This could fall under incitement to imminent violence. But it's also unclear whether propaganda includes incitement for war and also favorable reports of war already commenced. The same thing can be found in the Films and Publications Act 65 of 1969. So the idea that we have here is that, and this comes after World War II, where there was lots of propaganda for war. So the idea is that we should not have anything that supports or motivates war, but it's external aggression, so out of the country against other countries, not internal resistance to the government. Now here at the bottom you can see some examples. The most relevant or the most visible example is the one here. It's one of the Nazi propagandas where they say, "Der ist Schuld am Krieg." What they're saying here is the Jews' fault and we should have war. Then we here have Men of South Africa avenge. And this was against the war against the English, for example. And here we have a Russian war propaganda out of World War II saying that the US is busy with nuclear war. This can all be seen as propaganda for war. The next one we have is incitement of imminent violence. Now this comes from the US First Amendment jurisprudence. Now here the US First Amendment states incitement of an illegal activity. Now the question is, when does a call to illegality become incitement? So the question is, if you tell someone to do something, when are you inciting them to be illegal? When are you asking them? What is incitement? Now, you can read in your textbook some explanations on this, but what you need to know is the United States have 3 tests. The reason why you need to know this is because these 3 tests directly influence the South African jurisprudence on this. The first test they have early in the 20th century was the clear and present danger test. It was to determine the legitimacy of restrictions on freedom of speech. The question, they said, is whether the words used are used in such circumstances and of such nature as to create a clear and present danger that they will bring about the substantive evils that Congress has the right to protect. Later, they substituted this test with a reasonableness test that allowed the government to punish advocacy of illegality when it was reasonable to do so. And later on, the clear and present test was reformulated as a risk formula, where the speech was protected depending on the gravity of the illegal activity compared to the likelihood of it occurring. Now, in South Africa, our provisions, unlike the test in America, do not firstly require incitement to be likely to lead to violence. However, it will be practically impossible to determine whether a particular expression constitutes incitement of imminent violence without having regard to the possible effects it may have on its audience. So the context within which the statement is made is very. This is why the Supreme Court recognized in Brandenburg that the mere abstract teaching of the necessity to resort to violence cannot constitute incitement to imminent violence. So let's look at it again. In the American courts, there are 3 tests that they developed. Today, they use the risk formula test. The South African court was influenced by this, but the difference is we don't have a requirement that it needs likely to be leading to violence. But what the court will consider is the context within which the statement is made. If we are at a social gathering and somebody says we should bomb China and we should have a war with China, for example, or if you're at a social gathering and somebody says, you know what, the people of Gauteng and the people of Limpopo should actually just have a full-out civil war, and everybody laughs and continues with their day. This is not incitement of imminent violence. But if somebody says it to an angry mob of a crowd in Gauteng and they actually the chance of them attacking the people of Limpopo, that context would be a lot different. So the court also decided that it excludes abstract teaching because some teachings would promote the idea of resorting to violence or the necessity to resort to violence. There's a teaching that says that violence is the golden standard, for example. But this would not be incitement to imminent violence. Now, in South Africa, there was a Righteous Assemblies Act in 1956. Now, you'll see that is apartheid years. Now, Section 17 of this Act provides that a person is deemed to commit the common law crime of incitement to public violence if he has acted or conducted himself in such a manner, or has spoken or published such words that it might reasonably be expected that the natural and probable consequence of his act, conduct, speech, or publication would, under the circumstances, be the commission of public violence by members of the public generally, or by persons in whose presence the act or conduct took place, or to whom the speech or publication was addressed. Now, this was a very controversial act because it was used to stop people from protesting the apartheid government. So this act was written, and then suddenly nobody was allowed to protest because they were seen as part of the Righteous Assembly Act, and then these people would be taken to prison, released after a couple of days. But besides its controversial history, there are two reasons why this provision was found to be unconstitutional, and why it's incapable of giving effect to Section 16.2b. Because if you read it at first, it seems like it fits with this idea of incitement of imminent violence. But the first is that it envisions that public generally may be incited. Now, this is much broader than incitement to imminent violence, at least as it's understood in the US. The public generally. Now, the reason why they said the public generally is because there was such a big part of the public during the apartheid era that wanted to protest the government and violent protest the government. So that's the first thing, the fact that the word public generally is used. And the second is that the requirement of intention is removed by the provision. Nowhere it says that the speaker should have the intention to incite violence. So it's unlikely that Section 16.2b can be interpreted to sanction the criminalization of speech in the absence of intent. The removal of the ordinary mens rea requirement may also violate the right to the freedom of the person. So if you have to discuss incitement to imminent violence, you have to tell me that we take a lot of inspiration from the American courts, tell me there are 3 different tests in the American courts, and then tell me these 3 marks. So incitement to imminent violence in itself can be 10 marks that you have to discuss it. Then make reference of Section 16 of the Righteous Assemblies Act. You do not need to discuss the provisions of the Act. Just say that this is apartheid legislation, but say Section 17 of the Righteous Assemblies Act. Why it is unconstitutional? It refers to public generally, and it removes the intention provision. So this is the second type of speech that is limited. The first one, propaganda for war. Second one, incitement to imminent violence. The third one, hate speech. Remember, if I ask you to discuss the exceptions, I can ask this up to 30 marks. Make sure you know all the information that I put on the slides. It's a summary of your textbook. If there's anything on the slides you don't understand, consult your textbook. There, it's given in a lot more detail. Okay, now the third one we have is hate speech. This was drafted with the devastating consequences of the use of racist propaganda during the Nazi era fresh in the minds of the world. A number of the post-war human rights instruments restricted the scope of freedom of expression by preventing the incitement of racial hatred. Legal restrictions on hate speech are also imposed in a number of democratic societies. The Canadian Supreme Court has accepted the legitimacy of controls on hate speech and is therefore an important source of comparative jurisprudence in this area, as is the jurisprudence of the German courts. The immediate source of the hate speech qualification in 16.2 can be found in the draft Bill of Rights proposed by the African National Congress in the 1990s. But there was no specific reference to hate speech in the interim constitution. but the very first drafts of the Bill of Rights introduced in the Constitutional Assembly contained this qualification. The hate speech clause, according to an ANC negotiator, was written to send a powerful message that this type of behavior would not be tolerated in a democratic society where equality and human dignity were fundamental values. Now, this clause formulated excludes advocacy of hatred based on race, ethnicity, gender, and religion that amounts to incitement to cause harm from the ambit of the right of freedom of expression. Now, there must be two grounds present, or two elements must be present before an expression can be considered hate speech. The first one, the expression must constitute advocacy of hatred, and the second one, the advocacy from number one, must constitute incitement to cause harm. If these two elements are not present, it will not be considered hate speech. Now, if you look at the pictures we have here, this all comes from hate speech propaganda. This one, rotten, which is the the German word for rot or rat, is the idea that the Nazis created that Jews were like rats, vermin. So racist propaganda is whenever you reduce a human to an animal form or inhumane form or barbaric form. This is from the United States, where the idea was made that Japanese were always, they called it Jap time. It was given to children, propaganda given to children to instill a hatred in them towards Japanese people. This is actually Russian, and this is the idea that all Africans are barbaric and violent and they will eventually kill their enslavers. And this is all racist propaganda. We can see the same kind of things in South African history where Africans were reduced to vermin, and the other way around we have in. Now there are two cases that your textbook referred to with regards to case law. The first one is Freedom Front versus South African Human Rights Commission. There's a political slogan, it's also a song, kill the boer, kill the farmer. And this calls for the killing of people because they belong to a particular community or race. And they argue that this must amount to advocacy of hatred, unless the context clearly indicates otherwise. Now, this slogan is clearly advocacy of hatred based on race or ethnicity, as boer is a derogatory epithet for the Afrikaner. So this is one of the cases we had where hate speech, and today it's illegal to use this phrase. Another case we had was the Human Rights Commission of South Africa versus the SABC, where the Broadcasting Complaints Commission held that derogatory and inflammatory statements about the Indian population in a Zulu song were an advocacy of hatred based on race. Now, the song, according to the Commission, polarized Zulus with Indians by demeaning the Indians. The cause of property of Zulus are worse than the whites were, have turned an important clan into clowns, have depossessed them, have suppressed them, and played the fool with them. This was also found to be hate speech, because hatred was instilled in a community against Indians. So hatred was incited in Zulus towards Indians. Here, hatred is incited from the rest of South Africa towards Buddha or white people. Important case law to know for hate speech. If you have to discuss hate speech, there's enough marks here for about 15 marks. So make sure that you know enough about hate speech. Now, the last thing you need to know about hate speech is what is harm. In the Freedom Front case, the question was raised, what is harm? Hate speech is something that is done to cause harm, but what is harm? And the South African Human Rights Commission held that harm cannot be confined just to physical harm. So it's not just attacks. It should be taken to include physiological and emotional harm, and this is very important. So hate speech that causes physiological harm or emotional harm in a community can also be seen as hate speech. So there doesn't have to be any violence. It relied in part on the decision of the Canadian Supreme Court in R versus Keekstra, which described the types of harm that may result from hate speech. The Supreme Court stated that emotional damage caused by words may have grave psychological and social consequences. The court stated, a response of humiliation and degradation from the individual targeted by hate propaganda is to be expected. A person's sense of human dignity and belonging to a community at large is closely linked to the concern and respect accorded to groups to which he or she belongs. The derision, hostility, and abuse encouraged by hate propaganda therefore have a severely negative impact on the individual's sense of self-worth and acceptance. So if you have messages all over you telling you that the group you belong in is inferior or is morally corrupt or simply bad people, it has a psychological effect on you as a person that belongs to that group. You might not identify with the characteristics that hate speech is branding the group with. And this impact might cause target group members to take drastic measures in reaction, perhaps avoiding activities which bring them into contact with outsiders or adopting attitudes and postures directed towards blending in with the majority. Such consequences bear heavily in a nation that prides itself on tolerance and the fostering of human dignity through, among other things, respect for the many racial, religious, and cultural groups. The South African constitutional order, according to the Commission, is based on the same premises of human dignity and the promotion of inclusivity and tolerance of diversity. So what this is basically saying is that harm is not necessarily when you stand up and you say, let's say a person of the Xhosa tribe decides to tell everybody that the Zulus are really bad people and that we should murder them. Now this would be incitement to violence. But let's say this violence never happens. There's no physical harm. This goes on for a couple years and there's never any physical harms. But this Xhosa man that told his people that the Zulus are very bad, his message starts spreading. And let's say the whole of South Africa decides that the Zulus, for example, are really bad people. We can say Zulus, Tseperis, Afrikaners, English, whoever. And then somebody that's part of this group is so embarrassed and so psychologically harmed that they feel that they do not want to be part of their own ethnic group anymore. They feel that they'd rather just be part of the majority. And this has a direct effect on their self-worth and self-acceptance. This will also be harm. So you must be very, very careful as a citizen of a democratic country about what you say about other groups, the way you use derogatory terms when you refer to other groups. Okay, so this is all you need to know about freedom of expression. I guarantee you there will be a question exam and it will be between 15 and 30 marks. It will be one of two questions. Either you will be asked to discuss expressions afforded specific constitutional recognition, 16.1, or those specifically excluded, 16.2. But in your discussion, you must include explanation of section 16, that it consists of two parts. You have to tell me section 16.1, inclusion, 16.2, exclusion. Then you explain the two reasons why freedom of expression is important. This is on slide 3. And then you name each exception or inclusion, and you give 3 to 10 facts about each of them, which all you will find on the slides. So you just need to study exactly what I summarized for you. Let the content of the slides guide you.